Good morning to all of you. Welcome to Legal Matters by Sai Babu Sankara. We are going to discuss a decision given by the Orissa High Court. The topic is whether wife can file a case of harassment, simply to say 498 IPC case, from the place where she is residing other than her matrimonial home. So this is the question, and the simple answer is yes. There is no where, because even though you start while reading the section 178 CRPC also, previously I told some of you that the matrimonial cases, particularly the woman can file a case where she lived with her husband, where both of them lived together for some time, and where she is residing with parents. Here she is not residing with parents. She has left the matrimonial home also because the parents also deserted her. So therefore she can file the case as to where she is. Number one point. Then where should the investigation be done? Yes, the investigation may extend to more than one place also. The investigation, if it is more at one place, yes, even then these people can go to the particular place and they can inquire. So this is an important topic to be discussed in this particular case. Now you can read the case as Smt.Geeta Tiwari versus and another versus State of Orissa and another. Justice Gauri Shankar Shatapathy in this case. So while dealing with this case in criminal miscellaneous application number 2596 by 2015 on 16/1/2023 reiterated, once again held that the case can be placed at any place where she resides after being driven out of the matrimonial home also, because it was a continuing offense. Even though the parents deserted her, yes, it becomes a continuous offense. So please remember, actually the people, the husband and relatives of the husband, they filed a quash petition. You know, quash petition under section 482 CRPC as regards the case of 498A filed against them, stating that the case was filed in Bihar. That is, the entire incident took place in Dhanbad, Bihar. But she was in Sambalpur. She filed a case, she filed the FIR in Sambalpur. Entertaining the FIR at Sambalpur may be abuse of the process of law. So therefore, they requested to quash the petition, because entire incident took place in Dhanbad of Bihar. It is another state. Now she has come to Sambalpur and she is staying in Orissa and she filed the case. No doubt FIR was registered, because it is the onerous duty of the police to register a case, particularly a harassment case. So whenever a cognizable case is reported to the police under section 154 CRPC, they are destined, they are bound to register a case. As regards investigation also, matrimonial cases, yes, they have to investigate. But anyway, a petition has been filed before the Honorable High Court of Orissa, stating that it is nothing but abuse of the process of law, or I can say there is no necessity to conduct inquiry, to register an FIR in Sambalpur, because the entire incident took place in Bihar, Dhanbad area of Bihar. But please remember, so advocate on behalf of the government, he says that the allegation of torture was in Dhanbad and it had a consequence of mental trauma. It has a consequence of mental trauma even at Sambalpur. That means it is a continuing offense. Therefore, Sambalpur police, they have got jurisdiction. In this connection, Honorable, of course, the High Court also relied on the very famous case of Rupali Devi versus State of Uttar Pradesh 2019. So, place where the woman lives, it has got jurisdiction. No other point. So, please remember here, the typical point is that normally she can file the case where the husband was living, where the husband and she lived together for some time, or where she is living with family, But even though she is not living in the family, there also she can file the case. If you know this much, it is sufficient. So please refer to section 178 CRPC. It gives clarity. When it is a continuing offence, you can file the case at any place. If you know this much, it is sufficient. With this, I am concluding. Thank you very much.